shooting Chicago's South Loop this morning.
WGN's Courtney Spinelli joins us live from school.
Good evening to you both. Grieving family members and friends of the 31-year-old victim tell me she had just dropped her son off at school this morning when she was shot and killed. Now the woman who allegedly pulled the trigger is in police custody tonight.
It's so sad you can't even just think straight.
Not long after the bell rang at this elementary school Monday morning, gunshots rang out nearby, leaving a young boy without his mom.
I mean, what do you tell a kid? When you just drop me off, how do you just say she's not here anymore? How do you explain it?
Police say the 31-year-old victim, whose name has not yet been released, was near Cermak and State just after 9. Early information leads investigators to believe some sort of a fight unfolded and the suspect pulled out a gun, shooting the victim in the face. The victim was rushed to Stroger Hospital while the suspect was cuffed at the scene.
It's not fair. The person doesn't come back. You need to understand that. They don't come back. Your life is taken too. So who really lose? Everybody lose. It's no win in a situation.
Kanisha works across the street and saw the aftermath of what happened. She doesn't know the victim, but is devastated for her family and friends and calls this preventable.
Violence is not the way to keep doing it. Nobody wins in a situation.
A family now looking for justice, as sources close to the investigation say detectives are speaking with witnesses and reviewing evidence to figure out exactly what happened.
It's so scary and sad. I don't even know I feel real bad for the lady.
Now, the victim's loved ones tell me she was an outstanding mom who always showed up for her son. She had the purest soul, and she was the life of their friend group. Her family says she was working to become a nurse, something that was cut short. As of tonight, no charges have been filed against anyone in connection with her death. Live outside the 1st Police District, I'm Courtney Spinelli. Back to you.
There are moments in a courtroom where a judge stops reading from legal precedent and starts speaking like someone who has genuinely seen enough. December 4, 2025 was one of those days in a Chicago courtroom. And what Judge Castillo said that afternoon is now at the center of a defense appeal that, when you actually read the transcript, makes almost no legal sense. Today we're going through exactly what happened. Not the rumors, not the social media takes, the actual typed court record, word for word, because the truth of this case is more compelling than anything being spun online. This is the Romeca case. And if you haven't been following it, here's what you need to know before we go any further. Cuadesia Holly Johnson stands charged with first-degree murder and 5 additional counts in connection with the shooting death of a 31-year-old mother in Chicago's South Loop. The victim, known in this case as Romeca, was shot in broad daylight, steps away from a school, on the morning of September 8, 2025, right in the middle of rush hour drop-off. Children were nearby. Random bystanders stopped and stared. Multiple people called 911. And the whole thing unfolded on a busy city intersection in full view of the world. The defendant, Holly Johnson, claimed self-defense. The judge didn't buy it. And now the defense is arguing that the way he expressed that disbelief should be grounds for an appeal. So let's actually look at what he said. Because if you read it, really read it, the argument for appeal doesn't just weaken. It collapses entirely. Let's set the scene first. The morning of September 8th, Chicago. Rush hour. A mother named Romeca had just dropped her child off at school, a school surrounded by black iron gates on a busy south side corner. Within minutes of that drop-off, she was dead. According to witness testimony presented in court, here's the sequence of events as Judge Castillo laid them out in his detention ruling. The defendant, Holly Johnson, was in the area with witness 1, described in documents as the affirmative father of children shared by both the defendant and the victim. That detail alone tells you the emotional temperature of this situation before a single word was exchanged. Romeca, the victim, saw them. She stopped her car. What followed, according to multiple independent witnesses, people who had no connection to any of the parties involved, no stakes in the outcome, no prior knowledge of the history between these women, was a confrontation that escalated rapidly. And this is where the judge's words become critical, because he takes specific care to emphasize who these witnesses are. He notes, and I'm reading directly from the transcript here, that most of these witnesses don't know anybody. They have no stake in the game. They don't know the context. They are, in his words, literally random bystanders who happen to be observing this thing. That matters. That matters enormously. Because one of the foundational strategies in any self-defense case is to attack witness credibility, to suggest that the people who saw what happened had some reason to lie, some agenda, some bias. The judge is methodically closing that door before the defense can open it. So what did these unbiased witnesses see? They saw witness 1, the father, position himself physically between the two women, apparently trying to keep them apart. Multiple witnesses independently observed this. They all described the same scene, same sequence. They saw the victim, Rama, standing with her arms crossed. The judge specifically calls this out. Arms crossed. Not even remotely a threatening gesture, he says. She wasn't advancing. She wasn't reaching for anything. She was standing there. And then things shifted. Witness 1, instead of continuing to act as a buffer, began striking the victim with a car door. The judge doesn't gloss over this detail. He pauses on it because it's significant. Up to this point, no firearm had been mentioned. No gun had appeared. The physical aggression in this moment was coming not from the victim, but toward her, from the person who had moments before been standing between the parties. While this is happening, while the victim is being struck with a car door, witnesses heard Holly Johnson, the defendant, threatening to shoot Rama. Read that again. A threat to shoot, made while the victim was already being struck by someone else. While she was, by all witness accounts, not the aggressor. Then witness 1 put Rama in a chokehold. And it was at approximately that moment, while the victim was in a headlock and being struck, that the defendant went to her car, retrieved a firearm and returned. The victim, once free from the chokehold, began stepping backward. Away. That's the word the judge uses. She was taking steps away. And that is when the shooting began. Now here is the part that the judge found most telling. The part he specifically highlighted when discussing whether this could legally qualify as self-defense. He noted a pause. Between the first shot and shots 2 and 3 there was a pause. A deliberate pause. And then the defendant, according to witness accounts, ensured that the shots were fatal. The judge is careful here. He's not stating his own opinion out of nowhere. He's recounting what witnesses observed. But he says, and I want you to hear this clearly, I find it very telling that there was a pause between shot number 1 and shots number 2 and 3. This is a judge communicating, within the language of the law, that what he is describing does not resemble a panicked act of survival. It resembles something else entirely. After the shooting, according to witnesses at the scene, Holly Johnson fist-bumped witness 1. At a busy intersection. In broad daylight. Immediately following the shooting. The judge's response to this in the court record is measured but unmistakable. He says this behavior is wholly outside of the realm of anything resembling self-defense, or of anyone who would meet the legal standards of self-defense. He's not editorializing recklessly. He's applying a legal standard and saying that what witnesses described falls so far outside of that standard that it almost defies categorization within the self-defense framework. And there's one more detail he adds that often gets overlooked in coverage of this case. Despite the chaos of that morning, despite multiple bystanders calling 911, despite witness 1 being in a physical altercation with the victim, despite an active order of protection that was apparently in play, the defendant never called the police herself. Not before. Not during. Not after. The judge says explicitly, I was never told that this defendant called the police and said, hey, someone is violating this order of protection. I never heard anything like that. Everyone else at that scene reached for their phone and called for help. The woman who would later claim she acted in self-defense did not. Now let's talk about the appeal. Because this is what's currently circulating online and generating confusion. The defense is apparently arguing that Judge Castillo's language in this ruling was prejudicial, that certain words he used demonstrate bias and could be grounds for appeal. The words being flagged appear to include his use of terms like murdered, executed, and his characterization of the defendant's actions as demonstrating utter contempt for the law. Here's the problem with that argument, and it's a significant one. Read the transcript. Actually read it. Every time the judge uses strong language, he anchors it directly to witness testimony. He isn't freestyling his personal feelings about this defendant. He's summarizing what multiple independent eyewitnesses observed and described. When he says executed, he's using language consistent with what the witness accounts paint, a deliberate act after a pause following a threat that was heard by bystanders. When he says she celebrated after the shooting, he's describing what people standing on that street corner watched happen. A judge in a detention hearing is permitted, is expected, to weigh evidence and articulate findings. That's the job. Using accurate language to describe what evidence suggests isn't bias. It's function. And the other claims circulating online, that the judge essentially said he would deny any future appeals automatically, is directly contradicted by the transcript. What he actually said is that the court will revisit the order of detention at each and every one of your court dates. That's the opposite of a predetermined denial. That's a judge telling the defense that every court date is an opportunity to make their case. The appeal argument, at least as it's currently framed based on this transcript, doesn't have the foundation people online are claiming it has. There's also the matter of the defendant's background, which Judge Castillo addressed directly in his ruling. He noted that Holly Johnson had training and licensure in firearms, a concealed carry license. He did not present this as a mitigating factor. He presented it as an aggravating one. Think about that for a moment. The entire purpose of firearms training and CCL requirements is to ensure that people who carry weapons understand both the law and the profound responsibility that comes with that. You're taught when lethal force is and is not justified. You're taught de-escalation. You're taught the legal thresholds. The judge's point is that this defendant, with that specific training, still chose to do what witnesses say she did. The training wasn't a deterrent. It didn't function the way society designed it to function. And that, in his assessment, says something significant about the kind of threat this defendant poses going forward. Which brings us to prong 3 of his ruling, whether any conditions could mitigate that threat enough to justify pretrial release. He considered electronic monitoring. He considered home confinement. And he rejected both, not arbitrarily, but with specific reasoning, that the threat in this case isn't someone who breaks laws of opportunity, someone who might be deterred by an ankle bracelet or a curfew. The threat he identified is rooted in a belief system, what he called a twisted sense of self-defense, that verbal arguments can justify lethal violence. Electronic monitoring cannot change a belief system. It cannot intercept a decision that has already been made in someone's mind. That's the logic. You can agree or disagree with the conclusion, but the reasoning is documented, specific, and grounded in the facts of the case before him. Here's where this case sits right now. The next scheduled court date is March 3rd. Holly Johnson remains in custody. A motion for release can be filed. The judge explicitly informed her of that right, and the court will review the detention order at every subsequent appearance. The defense has the right to appeal. Everyone has that right. But the strength of an appeal depends entirely on finding a genuine legal error in the proceedings, not simply disagreeing with the outcome or the language a judge chose to use when documenting findings rooted in witness testimony. Based on what's in this transcript, the legal ground for that appeal looks thin. Very thin. What this case ultimately keeps returning to is something that sits outside of legal arguments and procedural motions. It's the reality of what happened on that street corner. A mother dropped her child off at school on a Tuesday morning in September. She encountered a situation that, by any account, she did not initiate with a weapon, did not escalate with physical aggression, and ended by stepping backward, away, when a gun was produced. Random people on their way to work stopped, watched, called 911, described what they saw, and they all described it the same way. The legal process will continue. Motions will be filed. Hearings will be held. And whatever happens in that courtroom, the record of December 4th is there, typed, documented, and very clearly readable by anyone who actually takes the time. The transcript doesn't support the appeal argument being made online. And the facts of this case, as documented in that courtroom, tell a story that is difficult to reframe regardless of how it's packaged. We'll keep watching. The next court date is March 3rd. And when new information becomes available from actual court records and verified reporting, we'll break it down the same way, with the receipts, not the rumors. If you found this breakdown useful, subscribe for ongoing coverage of this case as it develops. Every update we do is sourced directly from court documents and official records, because in a case like this one, that's the only thing that actually matters. There are moments in a courtroom where a judge stops reading from legal precedent and starts speaking like someone who has genuinely seen enough. December 4th, 2025 was one of those days in a Chicago courtroom. And what Judge Castillo said that afternoon is now at the center of a defense appeal that, when you actually read the transcript, makes almost no legal sense. Today we're going through exactly what happened. Not the rumors. Not the social media takes. Not the hot takes from people who clearly haven't read a single page of the actual court record. We're going through the typed transcript, the official documented record of what was said in that courtroom, word for word, passage by passage, because the truth of this case is more compelling, more layered, and more legally significant than anything currently circulating online. This is the Romeca case. And if you haven't been following it, or if you've been following it through secondhand commentary rather than primary sources, here's everything you need to know. We're starting from the beginning. We're building this story from the ground up. Because this is the kind of case where the details matter, not just for understanding what happened, but for understanding what justice looks like when it actually functions the way it's supposed to. By the time we're done today, you're going to understand the case, the courtroom ruling, the appeal argument, why that argument is legally weak, what happens next, and what this entire situation tells us about how the American legal system handles cases that live at the intersection of domestic conflict, firearms, self-defense claims, and public violence. This is going to be a long one. Stay with it, because the full picture is worth seeing. Cuadesia Holly Johnson is currently in custody in the state of Illinois, charged with first-degree murder and 5 additional counts in connection with the shooting death of a 31-year-old woman in Chicago's South Loop area. The victim in this case is referred to in court documents, and commonly in coverage of this case, as Rama. Rama was a mother. On the morning of September 8, 2025, she had just done what millions of parents do every single weekday morning without a second thought. She drove her child to school. She pulled up to the drop-off zone. She watched her kid walk through the gate. And then she began the process of getting back into her day. She never made it. Within minutes of that school drop-off, on a busy Chicago intersection in broad daylight, during the height of morning rush hour, Rama was shot. She died from her injuries. The defendant charged with her murder is Holly Johnson. Holly Johnson has claimed self-defense. And that claim, those 2 words, are at the heart of everything that has happened in this courtroom since. Because self-defense is not just a moral argument. It's a legal framework with specific, well-defined requirements. And what this case has demonstrated, through witness testimony, through physical evidence, and through the documented sequence of events on that September morning, is that the legal bar for self-defense was not just not met, it was missed by a distance that Judge Castillo found remarkable enough to comment on directly. Before we get to what the judge said, let's understand the charges. First-degree murder in Illinois is defined as knowingly and intentionally causing the death of another person, or acting with knowledge that such actions create a strong probability of death or great bodily harm. 5 additional counts accompany that primary charge, indicating that the state believes the circumstances of this crime extend beyond a single criminal act into a broader pattern of conduct that the law addresses separately. The state has argued that the evidence in this case, specifically the witness testimony from multiple independent bystanders, physical evidence from the scene, and the defendant's own actions before, during, and after the shooting, demonstrates not only that the killing was intentional, but that it was premeditated, that it was carried out in a way that shows deliberate decision-making, and that it cannot be excused or justified under Illinois self-defense law. The defense disagrees. And that disagreement is what has been playing out in courtroom appearances leading up to March 3rd, the next scheduled court date. But to understand the current appeal argument, the one that's generating so much online debate, you need to understand what happened on December 4, 2025, and why what Judge Castillo said in that courtroom that day was both legally appropriate and, frankly, damning for the defense's position. Before we walk through the judge's ruling, let's establish where and how this happened, because the physical context matters enormously to the legal analysis. The incident occurred on the corner of State Street and a nearby cross street on the south side of Chicago, described in court documents as the corner of State and Smarack, a location that court records note is a stone's throw from the residence of Witness 1. Witness 1, as we'll discuss in detail shortly, is a significant figure in this case, described in court documents as the affirmative father of children shared by both the victim and the defendant. His proximity to the scene on that morning was not coincidental. Directly across the street from where this shooting occurred was a school. A school surrounded by the kind of black iron fencing that marks institutional buildings in Chicago, the kind of fencing that tells you this is a place where children are supposed to be safe. The shooting happened across the street from that fence. Not a block away. Not down the road. Directly across the street. It was 9 o'clock in the morning. Rush hour. Parents were still in the area. Commuters were moving through. The streets were populated with ordinary people going about ordinary Tuesday morning routines. And yet on this particular Tuesday morning, a 31-year-old mother was shot on that corner, dying from wounds inflicted in front of strangers who had no idea, as they left for work and school that day, that they were about to witness a killing. The geographic and temporal context here is not incidental. It becomes central to the judge's ruling. Because one of the factors courts consider in cases involving self-defense claims is whether the response to a perceived threat was proportionate, whether it matched the level of danger actually presented. And shooting someone dead at 9 o'clock in the morning at a busy intersection across the street from a school, in front of multiple witnesses, is a set of circumstances that demands extraordinary legal justification. As we'll see when we read the judge's words, he found no such justification in the evidence before him. One of the most legally significant aspects of this case is the witness testimony. And to understand why, You need to understand something about how self-defense cases typically unfold. When a defendant claims self-defense, one of the primary battlegrounds is witness credibility. Defense attorneys work to establish that witnesses who contradict the self-defense narrative had reasons to lie. Personal relationships with the victim, biases against the defendant, incomplete vantage points, or motivations to misremember or misrepresent what they saw. This is standard defense strategy, and it's often effective, because eyewitness testimony is imperfect and human memory is genuinely unreliable under stress. But this case presented a witness situation that makes that standard strategy extremely difficult to execute. Judge Castillo, in his December 4th ruling, specifically paused to characterize the witnesses. And his characterization was precise. He noted that most of the witnesses who observed the events of that September morning don't know anybody. They have no stake in the game. They don't know the context. These are not friends of the victim. These are not enemies of the defendant. These are not people who had any knowledge of the history between these two women, the family court battles, the order of protection, the years of conflict that preceded this moment. They are, as the judge explicitly stated, literally random bystanders who happen to be observing this thing. And here is what makes this legally significant. They all described it the same way. When multiple independent witnesses, people who don't know each other, who have no shared motivation to align their stories, who have no relationship to either party, independently describe an event in substantially the same terms, that alignment carries enormous evidentiary weight. It's one of the strongest forms of testimonial evidence that exists in a courtroom setting, precisely because the normal vectors of contamination aren't present. There was no coordination among these witnesses. There was no shared bias. There was no shared agenda. They were strangers who happened to be standing on the same corner at the same time, and when investigators and prosecutors collected their accounts, those accounts told the same story. Understanding that is essential to understanding why the judge's ruling reads the way it does. He's not working from contested evidence or ambiguous accounts. He's working from a foundation of multiple consistent, independent testimonies, the kind of evidentiary base that tends to hold up even under rigorous cross-examination. Now let's walk through what actually happened on September 8th, according to the witnesses and as documented in Judge Castillo's ruling. The morning begins with Rama dropping her child off at school. This is the last normal moment of her life. She has done the thing parents do. She has made sure her child got safely inside. And as she is getting back into her car, as she is in the process of resuming her morning, she sees something that stops her. She sees Holly Johnson and Witness 1. Witness 1, remember, is the father of children shared by both women. His presence in this location, just around the corner from where the school drop-off happened, meant that these three people, connected by one of the most emotionally charged relationships in human experience, were suddenly occupying the same physical space at the same time. Rama stopped her car. What happened next, according to multiple witnesses, was a confrontation. An argument. Words were exchanged. And initially, according to witness accounts, Witness 1 positioned himself between the two women, a physical buffer, an attempt to keep them separated. This is important. At this early stage, Witness 1's actions suggest that even he recognized the situation was volatile enough to require physical separation. He wasn't watching from a distance. He was actively intervening. And multiple independent witnesses saw him do this. Now here is where the judge specifically highlights the victim's demeanor. Rama, according to these witnesses, was standing with her arms crossed. The judge doesn't let this detail pass without comment. He calls it out directly. Arms crossed is not even remotely a threatening gesture. She wasn't advancing. She wasn't reaching for anything. She wasn't lunging. She was standing with her arms crossed, engaged in a verbal dispute, while someone physically tried to keep her and the defendant apart. And then the situation changed. Witness 1, the man who had been acting as a buffer, suddenly shifted his behavior. He began striking the victim with a car door. Let that land for a moment. The person who had been separating the two women started using a car door as a weapon against one of them. Not against the defendant. Against the victim. Against the woman who was standing with her arms crossed. The judge notes explicitly that this happened before any mention of a handgun. Before any gun appeared. The first physical violence in this confrontation was not committed by the victim, and it was not committed by the defendant. It was committed by Witness 1, who had until that moment appeared to be attempting de-escalation. And it was at approximately this moment, as the victim was being struck with a car door, that witnesses heard the defendant make a specific threat. Holly Johnson threatened to shoot Rama. Out loud. In front of witnesses. While Rama was being struck by someone else, having not produced a weapon, having not made a physically threatening gesture, the defendant made a verbal threat to use lethal force against her. The significance of this in a self-defense analysis cannot be overstated. Self-defense law requires, among other things, that the defender be responding to an imminent threat. If you announce your intention to use lethal force before that force is used, before any weapon is produced on the other side, you are, legally speaking, not responding to a threat. You are announcing an offensive act while your counterpart's arms are crossed and someone else is hitting her with a door. This moment in the sequence is one of the most legally damaging elements of the case against any self-defense claim. The situation then escalated further. Witness 1 put Rama in a chokehold. A headlock. She was actively trying to break free. She was being held against her will, being struck, while the defendant was standing nearby having just verbally threatened to shoot her. And it was at this point that witnesses saw Holly Johnson walk to her car. She retrieved a handgun. The victim, Rama, having broken free from the chokehold, began taking steps backward. Away from the defendant. Away from the confrontation. The judge uses specific language here. She was taking steps away. Not advancing. Not charging. Moving in the direction that creates distance, not conflict. And Holly Johnson began shooting. Of all the elements in this case, the one that Judge Castillo singles out most specifically in the context of the self-defense argument is what happened between the shots. There was a pause. After the first shot, before shots 2 and 3, there was a measurable pause. A gap. A moment in which the defendant was not in the continuous physical flow of reaction but was instead making a decision. And then shots 2 and 3 followed. And then the victim was dead. The judge says, and I want to read this carefully because the legal weight of his words here is significant. He says, I find it very telling that there was a pause between shot number 1 and shots number 2 and 3. I don't know if shot number 1 would have been in and of itself fatal, but I know that there was a pause and then the defendant made sure that the shots were fatal. Now, some people watching coverage of this case have asked, why does the pause matter? If someone is shooting in self-defense, aren't pauses normal? Isn't it possible to pause out of shock, out of uncertainty, out of the chaos of the moment? Yes. In some circumstances that's plausible. But here's why the pause matters in this specific context. Self-defense law in Illinois, as in most states, requires that the threat be imminent and that the defensive response be proportionate and necessary. The moment the threat ceases, the moment the perceived aggressor is no longer actively threatening you, the legal justification for continued use of lethal force ends. If the first shot knocked the victim down or caused her to stop advancing, and remember she was already moving away before the shooting began, then the question becomes, what was the legal justification for the continuation? What threat was present in that pause that required shots 2 and 3? The judge doesn't answer that question definitively. He's not in a position to at this stage of the proceedings. But he is flagging it as legally significant, as a detail that tells him something about the nature of the defendant's actions. And what it tells him is that this was not a panicked, continuous defensive response. It was a deliberate sequence. A first action, a pause for assessment, and then a choice to continue. That distinction, between continuous panicked response and deliberate sequential decision-making, can be the entire difference between a legally justified shooting and a murder charge. If there is a single moment in this case that, more than any other, defines the legal and moral difficulty of the self-defense argument, it is what happened immediately after the shooting. Witnesses, multiple independent witnesses, remember, observed Holly Johnson fist bump witness 1. At the scene. In the immediate aftermath of the shooting. On a busy street corner, with the victim on the ground, with 911 calls already being made by bystanders, the defendant and witness 1 exchanged a fist bump. Judge Castillo's response to this, in the legal language of the courtroom, is about as clear as judicial language gets. He says this act is wholly outside of the realm of anything resembling self-defense or of anyone who would meet the legal standards of self-defense. Think about what a genuine self-defense situation feels like. You've just been forced to take a life. Even trained law enforcement officers who are prepared for the possibility of using lethal force typically experience profound psychological distress in the immediate aftermath of a shooting, even a justified one. Shaking, nausea, dissociation. The physiological and psychological response to having just ended a human life is rarely celebratory. It is rarely characterized by casual congratulatory gestures with a companion. A fist bump is not a traumatized person's response to having just survived a life-threatening encounter. A fist bump is a celebration. And celebrating at the scene of a killing, witnessed by multiple strangers, is the kind of detail that a jury will remember long after the legal arguments have concluded. The judge is not editorializing here beyond what the law permits him to say. He is doing exactly what a judge in a detention hearing is supposed to do: evaluating the evidence before him, applying the legal standards, and documenting his findings. And his finding is that this particular piece of evidence, the fist bump, is inconsistent in every meaningful sense with the self-defense framework the defense is attempting to construct. There is another detail in the judge's ruling that rarely gets the attention it deserves in online discussions of this case, but which carries significant legal weight. Everyone called 911. Witness 3 called 911 before the shooting, when the physical confrontation was escalating to a point where bystanders on the street recognized they were watching something that required police intervention. Someone else in the area called 911. After the shooting, Witness 3 called 911 again, this time having just witnessed a murder. There were active calls being made to emergency services by members of the public throughout this entire sequence of events. And Holly Johnson, the defendant, never called 911. Not before. Not during. Not after. The judge specifically notes this: "I was never told that this defendant called the police and said, 'Hey, someone is violating this order of protection.' I never heard anything like that. There was, apparently, an active order of protection in play between the parties. This is a court order, a legal document issued by a judge specifically because someone was found to pose a threat to another person's safety. If Witness 1 or if Rama was violating that order of protection through their presence or behavior, the legally prescribed response is simple: call the police. That's what orders of protection exist for. That's the mechanism the courts created specifically to handle exactly this kind of situation." Holly Johnson, with a CCL and weapons training with a legal background in the firearms she chose to carry, did not pick up her phone and dial 911. She did not call for the officers who are specifically empowered to enforce orders of protection. She did not use the legal system that had, presumably, been available to her throughout whatever disputes preceded that September morning. Instead, she produced a handgun. In any self-defense case, the question of whether the defendant exhausted reasonable alternatives before resorting to lethal force is legally relevant. It speaks to necessity, one of the core requirements for a valid self-defense claim. If a reasonable alternative was available and not used, the necessity of lethal force becomes much harder to establish. A 911 call was not just a reasonable alternative. It was the obvious, legally appropriate, legally supported response to exactly the situation the judge describes. And the defendant didn't make it while random strangers around her did. Here is something that the defense probably did not anticipate becoming an issue in this case. Holly Johnson's concealed carry license and firearms training were presented by the judge not as mitigating factors, not as evidence of responsible gun ownership, but as aggravating factors that made her conduct more troubling, not less. This is a nuanced legal and logical point that deserves careful explanation. In Illinois, obtaining a concealed carry license requires completing mandatory training. That training covers not just the mechanics of firearms but the law surrounding their use, specifically when lethal force is and is not legally justified. People who go through that training are taught about imminent threat requirements. They are taught about proportionality. They are taught about the obligation to avoid conflict when possible. They are taught that a firearm is a last resort, not a first response. The CCL framework, in other words, is specifically designed to ensure that people who carry weapons in public understand both the gravity of that responsibility and the legal boundaries that govern it. Judge Castillo's point is devastating in its simplicity. Holly Johnson had that training. She presumably sat through those courses. She presumably heard those legal standards. And according to the witnesses, she violated every principle that training was designed to instill: threatening to shoot before any gun was produced, drawing a weapon while the victim was moving away, pausing and then continuing to shoot, celebrating afterward. The training didn't deter the conduct. And the judge found that fact significant. Not because having a CCL makes someone a worse person, but because having that training and still engaging in this conduct demonstrates something about the defendant's relationship to the legal and ethical constraints that are supposed to govern the use of deadly force. He frames it this way in his ruling: despite the training, despite the licensure, despite what he calls societal norms, the defendant has proven that she will exert deadly violence over verbal arguments. That framing verbal arguments as the trigger is important. Because if the tipping point for this defendant's use of lethal force is a heated verbal exchange, rather than an imminent, proportionate, unavoidable physical threat, then the conditions that produced the events of September 8th are not anomalies. They are patterns. and patterns in a legal risk assessment predict future behavior. Illinois pretrial detention law operates on a three-prong analysis. To detain someone without bail before trial, the court must find, by clear and convincing evidence, that each of three conditions is met. Prong 1. Did the defendant commit the offense charged? The judge found that the state met its burden on this prong. Based on the witness testimony, the physical evidence, and the sequence of events as documented, he found clear and convincing evidence that the conduct described occurred and that the defendant was responsible for it. Prong 2. Does the defendant pose a real and present threat to the safety of any person or the community? The judge's analysis here is extensive and worth reading carefully. He begins by returning to the nature of the offense itself, not just what was done but how, where, and when. He notes that the killing happened after the victim had just dropped her child off at school. He notes that it happened in broad daylight. He notes that the defendant was undeterred, his word, by the presence of witnesses, by the time and setting, by the proximity to a school, by the presence of her own children nearby, and by the actions of community members who were already calling police. None of those factors slowed the defendant down. None of them produced hesitation or reconsideration. The social, legal, and moral gravity of the situation. A school, children, witnesses, daylight, a busy intersection, apparently registered as no barrier at all. He then addresses the fist bump again in this context. Not just as evidence of non-self-defense, but as evidence of a mindset. Someone who celebrates immediately after a killing in full public view is communicating something about how they processed what they just did. That communication is legally relevant to the question of future threat. He also returns to the firearms training. And his conclusion is stark. Someone with that training who still did what witnesses describe is not someone for whom the normal deterrents of social and legal consequence appear to function. His ultimate finding on prong 2, this defendant is absolutely a threat to the community and to these witnesses. Note the word witnesses. The people who saw what happened on September 8th are now potential targets in a case where the defendant believes, apparently, that verbal confrontations can justify lethal responses. The judge is not missing that implication. He is stating it explicitly. Prong 3. Are there conditions of release that could mitigate the threat? This is where the judge considers and rejects alternatives to detention. He considers electronic monitoring, the ankle bracelet system that allows defendants to be released under supervised conditions. He considers home confinement. And he rejects both, not on procedural grounds but on substantive ones. His reasoning is logical and carefully constructed. Electronic monitoring works as a deterrent when the defendant is deterred by the prospect of being caught. It works when the defendant can be trusted to comply with conditions, when their decision-making is governed by the recognition that violations carry consequences. It functions as a practical barrier to opportunistic conduct. But the conduct in this case, as described by witnesses, was not opportunistic. It was not impulsive in the sense of someone grabbing an opportunity. It was a sequence of deliberate decisions made in broad daylight, in front of witnesses, near a school, after an explicit verbal threat, with a pause for further decision-making between shots. And then a celebration. The judge puts it plainly, electronic monitoring would not deter the defendant from harming the eyewitnesses or anyone else she encounters that she would perceive as a threat based on their words. It cannot change the belief system that, by all evidence in front of the court, produced this killing. It cannot intercept a decision being made internally. It can only track a person's physical location, and location is not the issue. The issue, as the judge frames it, is a twisted sense of self-defense that appears to justify in the defendant's mind the use of lethal force over verbal conflict. He states his conclusion directly, "I give no faith that she would be able to comply with electronic monitoring, or that even if she was able to comply, electronic monitoring would in any way, shape, or form affect her apparently held belief that verbal arguments justify murder." Based on that analysis, he granted the state's petition for detention. Now let's get to the core of what's circulating online. The defense is pursuing what appears to be an appeal based on Judge Castillo's language in the December 4th ruling. The argument, as best as can be reconstructed from the available information, is that certain words the judge used demonstrated bias or prejudgment that undermined the defendant's right to a fair hearing. The specific words being flagged appear to include murdered, executed, and the judge's characterization of the defendant's conduct as demonstrating utter contempt for the law and basic societal norms. Let's examine each of these objections. First, the word murdered. The defense apparently objects to the judge using this word to describe what the witnesses say happened. But let's think about this logically. Holly Johnson is charged with first-degree murder. She is in a detention hearing related to a murder charge. The judge is tasked with evaluating whether the state has met its burden of proof on prong 1, which requires him to assess whether there is clear and convincing evidence that the charged offense occurred. Describing the killing as a murder in that context is not bias. It is the legal terminology directly relevant to the charge being evaluated. If a judge at a detention hearing for a robbery charge said, "I find clear and convincing evidence that the defendant robbed the victim," no one would argue that his use of the word robbed demonstrated prejudice. The same logic applies here. Second, the word executed. This is the one that seems to generate the most heat online. And I understand why. Executed is a viscerally powerful word. But examine the context in which the judge uses it. He uses it in the context of describing a killing that, according to multiple independent witnesses, involved a deliberate act, a pause between shots, and a continuation of shooting after that pause. Executed in a legal context does not mean the same thing as executed in a colloquial sense. It conveys deliberateness and intentionality, precisely the qualities that the witness testimony describes and that are legally relevant to the question of whether this was murder rather than self-defense. The judge is not inventing a characterization out of personal animus. He is using language consistent with what the evidence supports. Third, the claim about the appeal itself. This is perhaps the most significant distortion in online coverage of this case. Some accounts have suggested that Judge Castillo essentially said he would deny any future appeals automatically, that he prejudged future proceedings and telegraphed his intention to rule against the defense regardless of what they present. The transcript says no such thing. What the transcript says, explicitly, clearly, without ambiguity, is this: the court will revisit the order of detention at each and every one of your court dates. Read that again. The court will revisit the order at each and every court date. That is a commitment to ongoing review. That is a judge telling the defense that every single appearance is an opportunity to present new arguments, new evidence, new circumstances that might warrant reconsideration of the detention order. That is not a predetermination. That is the exact opposite of a predetermination. It is a standing invitation to make the case for release. The judge went out of his way to inform the defendant of her right to file a motion for relief and to confirm that the court would be actively reviewing the detention at every subsequent date. The appeal argument, as currently constructed, appears to be built on either a misreading of the transcript or a strategic attempt to introduce procedural delay into proceedings where the substantive facts are difficult to contest. Neither of those is the same thing as a legitimate appeal ground. A legitimate appeal requires demonstrating that a legal error occurred, not that you disagree with the outcome, not that the judge used strong language, not that the ruling was unfavorable to your client. It requires showing that the judge applied the wrong legal standard, that the evidence was improperly considered, that the defendant's rights were procedurally violated in a way that affected the fairness of the hearing. None of the words being flagged, murdered, executed, utter contempt, constitute legal error when examined in the context in which they were used. They are characterizations of witness testimony and documented conduct, made by a judge applying a legal standard in a proceeding specifically designed for exactly this kind of evaluative determination. There is one additional element of the December 4th hearing that deserves attention, because it's relevant to what happens next and because it's been discussed in ways that suggest some confusion about what Illinois law actually requires. During the hearing, the judge was informed that the defendant is approximately 7 weeks pregnant. This is not a trivial legal detail. Illinois has a specific statute, 725 ILCS 5/110-5.2, that addresses the pretrial detention of pregnant individuals. Under that statute, if the court reasonably believes that a pretrial detainee will give birth while in custody, the court must consider whether an alternative to custody is appropriate, unless, after a hearing, the court determines that no such alternative adequately addresses the risk factors that necessitated detention. The judge acknowledged this provision directly. He noted that at 7 weeks gestation, the question of whether the defendant will give birth in custody is not something that falls within the court's event horizon at this moment, meaning that at this stage of the pregnancy, the statute-specific procedural requirements aren't yet triggered in a way that changes the detention analysis. However, this is a developing legal question in this case. As the pregnancy progresses, as the due date approaches, the statutory provisions become more directly applicable, and the court will have to address them more specifically. The judge made clear that he is aware of the statute and will apply it appropriately as circumstances develop. What this means practically is that there is a future legal juncture in this case where the pregnancy may become the basis for a temporary release or alternative custody arrangement. The statute was specifically designed to address situations like this, where pretrial detention of a pregnant individual creates concerns about the health and safety of both the defendant and the unborn child. But, and this is important, even if the statute results in a temporary release or alternative arrangement as the pregnancy reaches term, that does not constitute a victory for the defense on the underlying case. It addresses the specific circumstances of the pregnancy. It does not resolve the murder charge. It does not change the evidence. It does not alter the witness accounts. It is a narrow procedural accommodation for a specific biological circumstance, and it should not be confused with a substantive legal win. There's a reason this case has captured so much attention beyond the specific people involved and the specific neighborhood where it happened. And it's not just the dramatic facts or the social media presence of the parties. It's because this case sits at the intersection of several of the most contested legal and cultural questions in contemporary American life. Self-defense law, specifically the expansion of self-defense claims and the stand-your-ground philosophy that has influenced legislation in multiple states, has been one of the most debated areas of criminal law over the past 2 decades. The question of when a person has the right to use lethal force, when the obligation to retreat applies, and how a defendant's subjective belief about threat is weighed against the objective evidence of the situation has been fought out in legislatures, courtrooms, and public discourse. Illinois does not have a pure stand-your-ground law in the same form as states like Florida. Illinois self-defense law requires that the force used be proportionate to the threat perceived and that the person using force believed it was necessary to prevent imminent death or great bodily harm. The subjective belief of the defendant is relevant, but it must also be objectively reasonable. An unreasonable belief, even if genuinely held, does not justify lethal force under Illinois law. That distinction, subjective belief versus objectively reasonable belief, is precisely where the self-defense claim in this case appears to founder. Even assuming Holly Johnson genuinely believed in that moment that she faced a threat justifying lethal force, the question is whether that belief was objectively reasonable given the evidence. A victim moving away from the shooter. A victim who witnesses described as having her arms crossed before any gun appeared. A defendant who verbally threatened to shoot before the gun was produced. A pause between shots. A fist bump afterward. An objectively reasonable person with firearms training, in possession of a CCL, facing the same circumstances, would not arrive at the conclusion that lethal force was the necessary and proportionate response. That's the legal test. And it's the test that the witness testimony, as documented in the judge's ruling, suggests this defendant failed. This case also raises questions about what happens when domestic conflict, the layered, complicated, emotionally charged history between people connected by children and co-parenting, moves from the family court system into public space. Orders of protection are imperfect legal instruments. They exist on paper. They require enforcement. They depend on compliance. When someone decides to resolve a dispute outside the mechanisms the legal system has created for exactly this purpose, the consequences can be catastrophic and irreversible. A 31-year-old mother is dead. Her child went to school that morning and came home to a world that had permanently changed. Witness 3, a stranger who happened to be in the wrong place at the wrong time, had to call 911 not once but twice, the second time to report a murder they had just watched happen. These are the human consequences that exist beneath all the legal arguments and procedural motions. The next scheduled court date in this case is March 3rd. That appearance will be, according to the judge's own words, another opportunity for the defense to present arguments for release or to address the conditions of detention. The defense has the right to file a motion for relief from the detention order, and based on the appeal arguments currently circulating, they are likely to pursue that avenue. Whether those arguments will find traction with a reviewing court depends entirely on whether they can identify a genuine legal error in Judge Castillo's December 4th ruling, not just language they find unfavorable, but an actual misapplication of law or procedure. Based on a careful reading of the transcript, identifying that error will be difficult. The judge grounded every major finding in witness testimony. He applied the three-prong analysis that Illinois law requires. He addressed the pregnancy statute. He informed the defendant of her rights. He committed to ongoing review at every subsequent court date. The ruling reads as a thorough, carefully constructed legal document, not as the product of bias or prejudgment. Meanwhile, the underlying case continues to develop. Witness preparation, evidence analysis, motions practice. All of the pretrial machinery of a first-degree murder prosecution is presumably moving forward on a parallel track to these detention proceedings. The trial itself, if it proceeds to trial, will be where the full self-defense claim is litigated before a jury. That is a different and much more extensive proceeding than the detention hearing. A jury will hear from witnesses. A jury will evaluate the evidence. A jury will apply the legal standard and make the ultimate determination of guilt or innocence. Everything that has happened so far, every courtroom appearance, every ruling, every motion, is prologue to that central proceeding. Here is what I keep coming back to when I read through this transcript carefully. The judge, in his December 4th ruling, does something that good judges do. He shows his work. He doesn't just announce a conclusion. He walks through the evidence, element by element. He identifies the witnesses, characterizes their independence, describes what they collectively observed. He applies the legal standard. He addresses counterarguments. He considers alternatives and explains why they don't apply. And then he reaches his conclusion. That kind of methodical documentation is not the hallmark of a biased proceeding. It's the hallmark of a judge who understands that his decisions will be reviewed, by appellate courts, by the public, by history, and who wants the record to reflect a rigorous, honest application of the law to the facts. The appeal argument that his language was prejudicial requires ignoring all of that context and focusing on a handful of words in isolation. It requires pretending that murdered and executed are impermissibly inflammatory rather than legally accurate descriptions of the charged conduct and the evidence supporting it. It requires pretending that a judge who explicitly committed to reviewing the detention at every court date was somehow predetermining all future outcomes. The transcript doesn't support that reading. And for anyone who takes the time to actually read it, rather than relying on secondhand summaries and social media takes, that much is clear. A 31-year-old mother is dead. The legal process is moving forward. The witnesses who happen to be standing on that corner on a Tuesday morning in September are part of this story now, whether they wanted to be or not. And the courts are doing what courts are supposed to do, applying the law, hearing arguments, making findings, and building a record. We'll continue to follow this case through every court date, every ruling, and every development, always going back to the primary source documents, always reading the actual transcripts, always separating what was actually said from what people online claim was said. Because in cases like this one, the truth matters. The details matter. And the difference between what the judge actually said and what people say he said is the difference between a real legal argument and a distraction. March 3rd is the next date. We'll be watching. If this breakdown helped you understand the case more clearly, subscribe for ongoing coverage. Every update comes from the actual court record. No speculation. No rumor. Just the receipts.